Welcome to the Court of Appeals. We have one case for argument today, and your panel this morning, I'm Judge Donna Stroud, as head of the panel, and to my right we have Judge Allegra Collins, to my left we have Judge Jeffrey Carpenter, and it looks like everyone is in place and ready to proceed, so we will go. We have need this down? Okay. We have the timer automatically set for 5 minutes of rebuttal. So if you need something different, let us know and we'll fix that. But is that acceptable? Okay. All right. Okay. Proceed.
Good morning, Your Honors, and may it please the Court. My name is Blake Abbott. I represent the appellants in this case. The appellants respectfully request that this Court reverse the Superior Court's dismissal of the complaint in this matter. Respectfully, Your Honors, the allegations in this complaint are relatively straightforward. Appellants make the allegations that the University of North Carolina system offers prospective students two distinct and separate products that it markets and also designates different prices for. At the beginning of the spring 2020 semester, appellants specifically bargained for, enrolled in, and prepaid in advance for the more expensive on-campus, in-person product. To no shock to anyone else, they received that product every day, week, and month leading up to March of 2020, until one day they were no longer receiving that product. Instead, they received a completely different product that they ultimately did not bargain for, and that was for the completely online, completely remote product offered by the University of North Carolina system. Although the North Carolina system was no longer offering access to on-campus facilities as well as in-person education, the University of North Carolina system elected to retain the prepaid tuition and fees for on-campus students, leaving the students to ultimately bear the burden of the university's breach. Today I mainly want to speak to three main points, Your Honors, and my first point being that the complaint adequately identifies and alleges alternative causes of action for breach of contract and unjust enrichment for services paid for and ultimately not received. Secondly, appellee is not entitled to immunity from this suit because appellee actually waived that immunity when it entered into contracts with the appellants and other similarly situated students. And lastly, the appellants have standing to sue the Board of Governors of the University of North Carolina system. So to my first point, North Carolina, just like other jurisdictions across the country, have recognized that the relationship between a student and the university is contractual in nature. And courts across the country have also recognized that this contract is an implied in fact contract that is comprised from several different sources, and that can include things such as publications from the university handbook, the university bulletin, oral communications given to by the university, and several other sources can actually come into play when creating the terms of this implied in fact contract between the university and its students. And based upon that standard, it is clear that in the complaint, appellants have sufficiently alleged the necessary elements for breach of contract claims for tuition, fees, room and board, as well as meals. This case, I'm sure that Your Honors are aware, is very similar to several other cases pending across the country in several other jurisdictions. There's well over 100 cases pending in several other jurisdictions, and my firm is fortunate enough to represent many of those cases. Several of these cases have survived on a motion to dismiss, and certain cases have even been reversed at the Court of Appeal level for decisions that had actually dismissed these claims for breach of contract. Most namely, the Schaefer versus George Washington case cited to by appellee in their briefing, where a member from my firm had actually had the opportunity to argue before the now Justice Brown Jackson. And I want to make clear that these contracts that exist between the students and the universities, so long as they don't call into question the nuances of educational judgment, are analyzed through the same scope as any other contract at common law. Here, the complaint alleges that UNC offered appellants and other similarly situated students, and appellants and similarly situated students ultimately accepted enrollment into the UNC on-campus program and in-person program. Further, appellants allege that the UNC system further differentiates between its on-campus and online program, not only through its registration process, but also by the way that it also prices its own two distinct products. In the complaint, it is alleged that the University of North Carolina system actually charges less money for its online product and also does not charge certain mandatory fees to students who enroll in its online product. In addition to this, this contract is further solidified by the course of dealings between the parties, because for the days, weeks, and months leading up to the COVID-19 crisis, students like appellants were able to have access to on-campus facilities and in-person education. And this was absolutely consistent with the University of North Carolina's 230-year-long history of providing on-campus education. We know even further that this contract is sufficiently specific in that the complaint contains allegations where, when registering for classes, the university itself actually breaks down the instructional method, the location at which the course is going to be taught, the professor that it's going to be taught in, and the specific campus that it's going to be taught on. And it is a combination of all of these things that give rise to this implied, in fact, contract that exists and existed between appellants and the University of North Carolina system for the spring 2020 semester.
I want to ask a question. So we're talking about tuition, which is the instructional method. We're talking about fees and then room and board. So we're talking about three separate contracts, or we're talking about one contract with covering sort of three separate types of dealings, or does it matter?
So I think it does matter, Your Honor, and thank you for your question. I think it is important to distinguish between the two. So there are actually 8 alternative, there's 8 causes of action in this case, 4 causes of action for breach of contract, and then the alternative for tuition, mandatory fees, room and board, and then also meals. So these are all separate contracts that are between the university and the students. So, I mean, Your Honor, you were correct that at this point in time, I was speaking directly to the tuition portion of that, but we also do make allegations as to mandatory fees, as well as housing and meals. And as to the mandatory fees, causes of action for breach of contract and unjust enrichment, we make those allegations in the record, and it's clear that based upon these mandatory fees that is charged by the university, that these are intended to support on-campus services. And we know this even more so because for the summer of 2020, the semester following the spring 2020 semester, at least one of the UNC system's constituent campuses announced that rather than charging the regular in-person rates for tuition and rather than charging the regular in-person mandatory fees, they would no longer be charging certain fees. And there were at least 3 that were campus-specific that students no longer had to pay for because the university recognized that it was not going to be able to proceed on an on-campus basis. And so in addition to the mandatory fees and breach of contract claims, we also do allege breach of contract and unjust enrichment for room and board and meals. And the basis of those claims are that basically there was an eviction or closure of campus that occurred sometime during the spring 2020 semester, and it might vary between campus to campus. But ultimately there was a closure of all of the campuses across the UNC system in which students no longer had access to the campus and those facilities as well as meals. based upon the eviction date, the refunds issued by the university system is insufficient. Essentially, from the date of eviction is where we measure our damages are from, but that is not commensurate with the actual refunds that were given by the university system. And so that's why we also bring the breach of contract claim for an unjust enrichment for room and board as well as meals. And I will say that in addition, our unjust enrichment claims also are valuable claims remaining in the alternative to our breach of contract claims for those 4 separate categories that I mentioned before. It's well established under North Carolina law that when an otherwise valid contract is discharged via some sort of avoidance doctrine, such as impossibility or impracticability or frustration of purpose or what have you, the appropriate remedy for a party that's already performed would be restitution. And so while it hasn't actually happened yet, we don't actually have an answer from the defendant in this case. It's safe to assume that they might bring with them some sort of affirmative defense of impossibility or impracticability or frustration of purpose brought on by the COVID-19 crisis that would be impacting its ability to perform under the contract. And that's why these unjust enrichment claims must remain in the alternative, because in the event, after sufficient discovery, we find that indeed performance was impracticable or frustrated in some way, shape, or form, restitution would still lie. And this was recognized in the University of Delaware decision where Judge Beavis from the Third Circuit Court of Appeals, sitting by designation, determined that, to be sure, even if there was a promise, the school was probably justified in breaking it. But that would not end the case here. Though impossibility might excuse performance, the school cannot be unjustly enriched. And so,
is it your position that, assume we agree with you for argument's sake, that there was in fact a contract between the students and the university, and there was a frustration of purpose where it couldn't be performed due to some act beyond the control of the university system, that you're still entitled to unjust enrichment under our law?
That would be correct, Your Honor. And I think that what you're getting at here is, what happens when a party enters into a contract and, maybe at no fault of their own, they're unable to perform that contract, then what happens? And I think that that's exactly where our cause of action for unjust enrichment lies, right? I mean, if after sufficient discovery we're unable to find, or we are actually able to find that performance was frustrated in some way, shape, or form, that still wouldn't necessarily allow the system to retain all of the prepaid funds that the students had already paid under the contract. And so there, our unjust enrichment claim would necessarily need to survive.
So the allegations are there's a contract that's been breached. The remedy for that would be whatever the damages would be for a breach of contract. Separate body of law and equity of unjust enrichment. I believe where no contract existed, but certain services were performed in a non-gratuitous way. How do we merge the two bodies of law?
Absolutely, Your Honor. So I guess as far as merging the two bodies of law, what we're sort of getting at here is that that restitution comes from that unjust enrichment claim that is lying in the alternative. And underneath North Carolina law, that is the remedy for an individual who's already performed under a contract, but actually cannot avail themselves of that breach. As far as merging the two bodies of law, I think that they necessarily are intertwined, especially in a case such as this, where an anticipated offense such as impossibility can be foreseen. Absent the unjust enrichment cause of action in this case, it is possible that a breach could not be found, and therefore, on that basis alone, the university would be able to unjustly so retain the fees that were prepaid by the parties, specifically the appellants in this case, for services that were ultimately not delivered for the entirety of the spring 2020 semester.
So let me just see if I understand. You're alleging in the alternative either breach of contract, which would be damages, or restitution, but ultimately you're going to measure the amount of either damages or restitution in the same way. Is that feasible?
So that would be correct, Your Honor, absolutely. And we know that we can do that without actually calling in too much speculation by a variety of things. And a great starting point would be the university itself's own differential in the cost that it charges its students for tuition and fees. You know, as we've alleged in our complaint and is true going into the spring 2020 semester, at least one of the constituent campuses across the system charge significantly less tuition for on-campus courses. And at least one of the constituent campuses across the system actually didn't charge certain mandatory on-campus fees. And so that's a good place to start.
Can I just ask, you had mentioned somewhere that you said that the refunds were insufficient based on the eviction date. Is that, there was some money that was refunded, am I?
That's correct.
Right. Is it possible that either under breach of contract or restitution that these funds that were paid up front, there are lots of times when certain things are paid up front, a larger amount is paid up front because you have to set up whatever it is, whether it's the meal service or whether it's the campus on housing, and then thereafter the monthly payment per se is less than that up front.
Could you repeat your question,
Yeah,
please?
sorry, that was circular. So my question is are there contracts where your fees up front are more expensive than the subsequent monthly payments, such that it's not divided into, say, 9 individual equal payments for housing, but it's one large payment up front and then 8 smaller payments going forward?
Okay, I understand. I suppose that is very possible, Your Honor, but I don't think that that's the case in this situation. This is a situation where the students actually paid for everything up front, and they didn't have any subsequent payments thereafter. And so I think that the appropriate measuring stick there is, you know, we paid for room and board for the entirety of the semester, and that, you know, by whatever academic calendar might be some 120, 110 days. We got evicted after 50 days. Therefore, we deserve a prorated amount for the amount that we were ultimately not refunded for. So let's say, you know, some span of time, 2 weeks, let's just say, for example, would be the appropriate measuring stick there. But I think that, based upon your question, that it's certainly possible, but I don't think that that's the case in this situation. And accordingly, I mean, appellants asked this court to reverse the Superior Court's decision to find that the appellants have indeed adequately stated alternative claims for breach of contract and unjust enrichment for room and board, tuition, fees, and meals. To my second point, the university system is not immune from suit in this case because the university actually waived that immunity when it entered into contracts with its students. Under Smith v. State, that case found that whenever the state actually enters into a valid contract with an individual, the state implicitly waives the sovereign immunity that it has in the event that it actually breaches a contract. So the purpose of this was that the state would be able to contract with an individual citizen. If the state were to ultimately breach that contract, that individual citizen wouldn't be faced with the state sort of saying, well, I'm sorry, but you don't actually have a remedy here. And I think that this is very important and very crucial to this case because, as we discussed before, the relationship between a university and a student is contractual in nature. And so when they enter into this contract, when the university offers its on-campus product and the appellants perform under this contract and pay their tuition and fees, that right there is the creation of a contract, and that right there rises to the level of the meeting of the minds and a mutual assent that is sufficient to implicitly waive that sovereign immunity.
If a student were to withdraw in the middle of the semester, would they get their money back? On the students in a normal situation, if a student withdraws, does the student get back the prorated portion that they didn't use?
Yes, Your Honor. So it's a little bit unclear based upon the record specifically, but to answer your question, that's an event in which the student actually had voluntarily left, and depending on whatever campus's relevant tuition fee refund schedule would be, they ultimately might not be entitled to a refund if they were to withdraw. Essentially, they're paying for something, they're receiving the benefits of it, and at no fault of the university, the student is no longer availing themselves of the benefits of that.
What happens if the student's in an accident and they're in the hospital and they can no longer avail themselves of the education through no fault of their own?
Yes, Your Honor, I suppose in that situation it would be more of a more factual intensive question depending on more specific language around the contractual agreement between the parties. But I believe in that situation, if the student was involved in a car wreck and ultimately the university continues to perform under the contract, the student would not be able to sue the university for refunds for tuition and fees, merely because they themselves were in a car wreck and unable to avail themselves of the services. But that's certainly not what happened here. The difference here is that we have appellants that have completely performed under the contract. They prepaid their tuition, they prepaid their fees. They know what they're going to get, and that's an on-campus education. But halfway through the semester, the university actually stops performing. And instead of refunding appropriate amounts of tuition and fees and prepaid funds for meals, the university just elects to retain the monies, and that's certainly where the problem that we run into here is. So, I mean, basically, it's clear under these circumstances and based upon the allegations contained in our complaint that UNC had entered into contracts with the students to provide on-campus in-person education in exchange for tuition and fees, and by doing so, had implicitly waived the sovereign immunity that it retains naturally. And I do want to make clear that, and I think that this is addressed somewhat in the papers, that this waiver would apply equally to our alternative claims for unjust enrichment as well. And here's why. Because the whole point and purpose of that implicit waiver of sovereign immunity is this mutual assent, this meeting of the minds that, you know, I know what we're contracting for, I know what I'm undertaking, and therefore I am implicitly waiving my sovereign immunity. So it would be difficult, based upon our claims in the alternative for unjust enrichment, to conceive of a situation in which the university waives its sovereign immunity for this undertaking that it took at the beginning of the spring 2020 semester. We later find out that, you know, maybe after some factual development that it was impossible or impracticable or frustrated by any purpose. And then all of a sudden it gets that immunity back. That's certainly not the situation, and that's not the way that that's not the way that the waiver of sovereign immunity is intended to work, and therefore it would actually apply equally to our unjust enrichment claims as well. To my next point, I do want to talk about standing in this case. At the lower level and as well as in the papers presented before this court today, appellee has brought into question whether or not the appellants in this case can adequately bring a lawsuit on behalf of students who actually attended other campuses that the appellants themselves did not. And I think that it's important to recognize that at this stage, that's sort of an inappropriate question. Rather, it's a much more appropriate question for the class certification stage, because here I think it's very clear that the appellants in this case would have standing to sue the Board of Governors of the University of North Carolina for the injuries that they have suffered. They're bringing it as a putative class action on behalf of other students who have suffered a similar harm as them, that being the uniform conduct by the university with its decision to shut down all of its campuses across the entire system. Now, at a later date, after some discovery, we eventually move on a class certification issue.
If I could ask you, I'm sorry to get you off, but I want to make sure you address this. Regarding the effect of the statute and the constitutional issue you've raised about the retroactive application of that and the fact, or is this a facial or applied challenge?
Sure. And I believe that you're speaking to the emergency immunity statute that was enacted in late June of 2020. Okay. So So that would be, section, 116.311. And essentially what that statute does, and this was passed, as I said,
Right.
in June 25th, 2020. The effect of this statute is to provide immunity to the universities across the system against claims relating to acts or omissions related to payments of tuition and fees, and reasonably related to the services of providing their educational products. And essentially, our position is, and I think it's pretty clear from the plain reading of the statute, that it simply does not apply to breach of contract claims. And here's why: because when in North Carolina, when we're construing statutes that necessarily infringe upon common law property rights, they must be narrowly construed. Basically, we need to give them exactly the language for which they provide. And the provided language in this situation is protections against claims for acts or omission. And it's very clear, based upon the complaint, that we don't make any allegations that there was a negligent act or omission.
Well, let's assume, just for purposes of argument, that it could apply to a contractual claim relating to fees and tuition and not a negligence claim.
Okay, so I guess for the sake of argument that it possibly could apply to a contracts claim, even in that situation, in its application, it would be unconstitutional under the circumstances. And there's a couple of reasons for that. The first reason would be that this retroactive statute would actually impact, an existing contractual obligation, and that would violate the Contracts Clause of the United States Constitution, which essentially says that no state can pass a law that infringes upon the contractual rights or pre-existing contractual rights of individuals. And in this situation, there is a contractual right. The contract was actually entered into at the beginning of the spring 2020 semester. It was entered into 6 months prior to the actual, adoption of the statute, and 3 months before the statute was designated to start from. I think they designated the statute to start from March 27th or March 24th or something like that. So this contract actually existed long before this happened. And basically, the university, after waiver of its sovereign immunity, had undertaken a contractual obligation. And now the legislature is passing a law that ultimately frustrates that. They were going to relieve the school system from its contractual obligations to its students. And that in itself is a violation of the Contract Clause of the United States Constitution, and therefore by its application is unconstitutional in this situation, assuming it could possibly apply to contracts, which of course we don't take the position that it does. Additionally, this would be a violation of the due process clauses of the United States and of North Carolina. And I think that to put this in perspective, I would draw Your Honor's attention to the Fior versus the University of Tampa case, which was submitted in our papers. This is a similar case than the one at hand. This involves a tuition and fee refund action against the University of Tampa. And I don't know if Your Honors are aware, but there was a statute passed in Florida that was much more specific and to all claims related to COVID-19. That statute itself said, we need to relieve these schools of all claims related to refunds of tuition and fees. Clearly, that would include contracts. And so the judge sitting on that case decided that, or determined that, it was clearly a violation of due process, because what had happened in this case was the students had entered into contracts. That contract was then breached. That created a chosen action, and that is a private property right to an individual. And essentially, the legislature passed a law, just like the same as here, that said, we're going to take that chosen action away from you. And that in of itself is a violation of due process. And so consistent with the Fior versus University of Tampa case, I would respectfully request that this court, should it find that this statute could potentially apply to contracts, apply that same reasoning and recognize that this would actually be a violation of the Due Process Clause in North Carolina as well.
And, I'll give you a little extra time since I hit you with that right at the end. But anyway, you're almost out, so.
Yeah, absolutely, Your Honor, and I appreciate the extra time. I don't think you derailed me too much, but basically, to wrap up my standing argument, the appellants in this case clearly have standing to sue the Board of Governors. The question of whether or not they can sue on behalf of all students across all the campuses is not necessarily a question for here and not a question for standing. That is much more a question for a class certification issue, whether or not the named appellants in this case are adequate and typical of the other putative class members that they seek to bring this case on behalf of. I see that I've run out of time, even though Your Honor, Judge Stroud has granted me extra.
I'll give you a little extra on rebuttal. So.
Okay, I appreciate that. Thank you.
All right. Fancy. I don't think I knew that it did that.
I didn't until today, and it's really cool.
Oh, right. That's new, right? Is that
Thank
new?
you.
Oh, okay. I don't usually stand over there, so it's nice. Okay, I'm glad I know that. Very good.
Good morning. May it please the court, my name is Jim Phillips. I'm here with Jennifer Van Zant and Katie Wong with the Brooks, Pierce, Micklin, and Humphrey and Leonard firm, and with our colleagues Laura McHenry and Kari Johnson from the North Carolina Department of Justice on behalf of the UNC Board of Governors. We ask today that this court affirm the order entered by the trial court dismissing plaintiffs' claims for breach of contract and unjust enrichment. The trial court had multiple bases for dismissing plaintiffs' claims. First, those claims are barred by GS 116-310 et sec, which immunizes these universities from these claims. Second, sovereign immunity bars claims against the university, an agency of the state, because plaintiffs have failed to plead the terms of an express contract between them and the universities. Third, that same failure to allege the terms of the purported contract compels dismissal on 12b6 grounds. North Carolina law is clear that in the education context, it is not enough to point to and rely on statements in websites, in handbooks, in bulletins, in marketing materials, and the like for the terms of a contract, unless those terms are then imported into an express agreement between the parties. And finally, North Carolina's well-developed law on educational malpractice compels dismissal. I'd like to talk first about the immunity statute that Judge Stroud referenced. In 2020, after the onset of the pandemic, the General Assembly made the policy decision stated in GS 116-310 that it is a matter of vital state concern affecting the public health, safety, and welfare that institutions of higher education continue to be able to fulfill their educational missions during the COVID pandemic, and that they be able to do so without civil liability for any acts or omissions for which immunity is provided in this article. That law says that immunity applies from March 10th, 2020, when Governor Cooper declared a state of emergency, until June the 1st, 2020. It specifies 4 criteria that must be met for the statute to apply. In short, the claim arises out of or in connection with tuition or fees paid to the institution of higher education for the spring academic semester of 2020. Second, the claim alleges losses or damages arising from an act or omission of the institution of higher education during or in response to COVID-19. The alleged act or omission by the institution of higher education was necessarily related to protecting the public health and safety, and the institution of higher education offered remote learning options for enrolled students during the spring academic semester of 2020 that allowed students to complete their semester's coursework. All of those requirements are met here. Plaintiffs make 2 arguments in response to this statute. The first one is that they contend, as you just heard, that this applies only to tort claims. But the statute itself defines claims, and it defines claim as a claim or cause of action seeking any legal or equitable remedy or relief. That would certainly include claims for breach of contract. So it's abundantly clear from the plain language of the statute that it covers the claims at issue here today, because it covers any claims for relief. The second argument that plaintiffs make is that the statute is unconstitutional. But that argument fares no better for 2 reasons. First, as this court is well aware, in North Carolina, plaintiffs bear a high burden to find and argue and prevail on the notion that a statute is unconstitutional. First, the statute is, of course, presumed constitutional. And then plaintiffs must show that it is not beyond a reasonable doubt. That is a high bar. Despite that burden, plaintiffs' argument in their briefs is no more than a reference to a laundry list of constitutional provisions and citations to the Federalist Papers and out-of-state cases. That is woefully short of meeting the high burden to show that the statute is unconstitutional beyond a reasonable doubt. In addition, plaintiffs' constitutional challenge was not raised on a timely basis. This is clearly a facial challenge to this statute. Below, plaintiffs made a sweeping argument that the statute was unconstitutional in their papers. They did not assert in their brief when they first raised it that this was an as-applied challenge. They just said this statute is unconstitutional. And the statute itself makes clear that this challenge must be facial. The statute applies in only limited circumstances, only for a very limited amount of time. It applies only to claims related to tuition and fees paid for the 2020 spring semester. It applies only if the university provided online education and students were able to obtain credit for their coursework. In short, this challenge basically has to be facial because it applies the same way to any plaintiff who would bring a claim here. And as a facial challenge to an act of the North Carolina General Assembly, Rule 42B4 of the North Carolina Rules of Civil Procedure requires that that challenge must have been raised in the complaint, in the amended complaint, in the answer, or by the defendant in the answer, a motion to dismiss, or within 30 days of filing the answer. Plaintiffs failed to raise that challenge. In fact, plaintiffs could have raised the challenge, as Rule 42b-4 tells them to do, because after they filed their amended complaint, the defendants, and this is at pages 44 to 46 of the record, the defendants filed a motion to dismiss. And in that motion to dismiss, one of the grounds for dismissal that we listed was this statute. And then plaintiffs filed an amended complaint. But in that amended complaint, they failed to raise the issue that this statute was unconstitutional, as Rule 42b-4 requires them to do. That failure to timely raise this constitutional issue acts as a bar, a procedural bar to them raising it now, as or below as they did in their brief. Now, that's not surprising because the law is full of rules that say if you don't do something in a certain way or by a certain date within so many days, then you waive the right to pursue that argument. If you don't raise an argument below, you waive the right to pursue that argument here on appeal. If you don't brief something, you waive the argument to have the court consider it. If you don't file a notice of appeal within 30 days, you lose your right to appeal. I could go on and on. So there is nothing surprising about the fact here in Rule 42b-4 that there are specific ways to raise this challenge. Plaintiffs failed to do that. They have waived it.
Plaintiff's original complaint was filed in May of 2020. The statute had not been enacted at that point in time. The amended complaint relates back pursuant to the Rules of Civil Procedure. So how do we deal with the conundrum created there? It relates back to the original filing, but the statute wasn't in place at the time of the original filing.
No, but it certainly was when they filed it, Your Honor. And as in the record, the statute was in place when they filed their amended complaint.
The amended complaint.
That's right. And so and that's what the rule says. The rule says it's okay to file it in a complaint or to raise the issue in a complaint or in an amended complaint. It specifically contemplates that in Rule 42b-4. And we put them on notice that we're raising this statute. And then in response to that, a month later, when they filed their amended complaint, no mention.
So if I understand your position, had they not filed an amended complaint at all, you wouldn't have raised the issue?
No, Your Honor, we raised the issue in response to their complaint. Then they came back and amended their complaint because we hadn't filed an answer. So we filed our motion to dismiss. They filed an amended complaint on notice that we were raising this issue. And they failed in the amended complaint to raise the issue of unconstitutionality. That, under Rule 42b-4, means they can't waive it, they can't raise it later. Let's turn, members of the court, if you would, to their breach of contract and unjust enrichment claims. Plaintiffs' claims, as they note, are all one or the other, either for breach of contract or unjust enrichment. And even if the immunity statute that we just talked about doesn't bar those claims, other North Carolina law does. First, let's talk quickly about unjust enrichment. It's black letter law that sovereign immunity bars plaintiffs' unjust enrichment claims. Sovereign immunity, of course, bars a suit against the state unless it's consented to be sued. And it's undisputed that UNC is an agency of the state. This, with regard to their unjust enrichment claim, the cases we've cited, Whitfield, Data General, M-Series Rebuild, state plainly, black letter law, you can't bring an unjust enrichment claim against the state. That's barred by sovereign immunity. Period, paragraph. So those claims should be dismissed. With regard to their contract claims, they fare no better. It's important to note that plaintiffs don't point to any written contract as the basis for their contract claims. Rather, they say they have an implied contract with the university for on-campus in-person instruction and for the experience that that gives. So, where do those claims come from? Where do the terms of the contract come from? Where are they found? At paragraph 147 of the complaint, the plaintiffs answer that question. The terms of the contract are as implied or set forth by a defendant through its website, academic catalogs, student handbooks, marketing materials, and other circulars, bulletins, and publications. And then they go on for paragraphs after that to refer to specific statements in those marketing materials and websites and the like. At paragraph 220 of the complaint, they say that the terms of the purported fee contracts come from, a quote, university publications, particularly its catalogs and its websites. So to be clear, plaintiffs allege that the terms of the contract and the university's agreement to enter into a contract are not found in any written agreement, but in these websites, catalogs, marketing materials found online. Well, North Carolina law is clear that allegations of just this sort are insufficient to state a claim for breach of contract or for the formation of a contract against a school. There are three reasons for that. First, ignoring for a moment the heightened pleading standard required for sovereign immunity, North Carolina courts have repeatedly dismissed claims, contract claims, that rely on similar statements found online and in similar books and marketing materials that are relied on by plaintiffs as the basis for a contract. In this court's decision in 2016, in Montessori Children's House of Durham against Blizzard, plaintiffs claimed that a contract existed based on statements in the school website that said that the school had a 10-to-1 student ratio, teacher-to-student ratio, and that there were no more than 20 students in a class. Parents, plaintiffs brought an action saying that that formed a contract between the parents and the school, or the student and the school. But this court rejected that argument vehemently. The court said, defendants have failed to direct our attention to any controlling case law, or for that matter, any case law at all, holding that statements contained on a private school's webpage or in advertisements that are not expressly incorporated by reference into a contract for admission to the school should nevertheless be treated as binding contractual terms. It's also important to note that the statements forming the basis for defendants' argument were not promises at all. Rather, they simply described characteristics of the school's classes that existed at the time and did not purport to make any commitment that those characteristics would not change. Those kinds of statements, rejected by the court in Montessori, are exactly the kind of statements that plaintiffs rely on here as the basis of their contract. No more. Exactly. The Montessori court went on to note, and I think this is important because it shows the slippery slope that relying on the kinds of things that plaintiffs point to as contract terms can lead to, the slippery slope you end up on. Defendants, the court said, defendants offer no viable objective principle for differentiating between, on the one hand, statements on the school's webpage that merely describe certain characteristics of the school that are potentially subject to change, and on the other hand, statements on a webpage relating to aspects of its operation that the school is legally bound to maintain and that are impliedly written into every contract between the school and the parents of an enrolled student. And we are unable to find any such principle. That is, in fact, a slippery slope.
So I want to ask a question. If barring COVID, barring the statute, okay, you have a student who pays and enters UNC and pays the tuition, pays the fees, pays the room and board, and one day UNC says, we're not doing this anymore, period. Is there a cause of action, any cause of action, and if so, what is the remedy in that situation?
Your Honor, let's look at this particular situation. So classes started first week of January. Exams started the end of April, last week in April. The plaintiff alleges that students were asked to leave campus on March the 23rd. So basically a month before the semester was over and a little over 2 months into the semester. So that's not unlike the hurricanes that we've seen. That's part of the slippery slope here. In Wilmington, at East Carolina, school gets canceled for a week, 2 weeks, sometimes more. Plaintiff also said that North Carolina has recognized that the nature of the relationship between a student and a university is contractual, not by my reading of the case law. And so, in fact, this court, Ryan, other courts have been loathed to find contracts in these situations and have required very specific agreements between them. You know, in this situation, Your Honor, I think they are not entitled to recovery. I can't tell you, if the school provided nothing, if they walked on and from the beginning of the semester to the end. The other thing I would say is we believe the nature of the relationship here is statutory. If you look at GS 116-143, it specifically requires that the university and that the Board of Governors set tuition and fees, that those tuition and fees be charged, that they be collected before the beginning of the semester. And the statute goes on in Section C to disallow a waiver of tuition and fees.
Okay, so going back to my question, if somebody pays for all of those things per statute up front, and those things that they paid for are not provided, is there any cause of action ever? And if so, what is that cause and what's the remedy?
Your Honor, I don't know. I know there's not a breach of contract claim based on what the plaintiffs have put in front of this court, relying on websites and marketing materials. You know, one of the things I've thought about is when I file a lawsuit, I pay filing fees. During COVID, you know, as I looked around, if you look around the different judicial districts, you see rules that tell you you should expect to go to trial within 6 months or 12 months or whatever. During COVID, none of that happened. But I paid the government to file my lawsuit. I had to pay a filing fee. Because the court system didn't run exactly the way that it had run before, am I entitled to a return of my filing fees?
Was your case ultimately heard?
It was.
Okay, so were these students allowed to defer?
In fact, they continued to receive online education.
But were they allowed to defer and get the tuition, the type of classes, the food that they paid for at a later date?
You know, Your Honor, I don't think so, but I don't know that as a matter of fact. But, you know, I had many, many online hearings during COVID where I did not do what we're doing now. Did that entitle me to a refund? I think not. I think quite frankly that the university did a magnificent job here, transitioning to online and providing that semester's education to these students. I think that these students, and I think the General Assembly recognized it when it passed the immunity statute, that this was a hard job and the university pulled it off. None of us got exactly what we were used to paying for during COVID, but we got what I would consider to be, if there was a contract, substantial performance.
Well, let me ask, and I like the way you took our silly hypothetical and turned it into a different silly hypothetical. That was very good. But still, just sort of the bigger question remains. Like I said, that the hypothetical of, you pay for your full tuition and everything up front. For whatever reason, I realize this is a silly hypothetical, the university just says, yep, we're not doing it this semester. You only had like 2 days of classes and then they just stopped. No valid reason, no hurricane, no anything. Hopefully that would never happen. I understand that. But what would that claim be? So if you wanted to say, hey, I just paid $50,000 and got nothing, what would it be? And I know you said you don't know. And that's a valid answer. But,
Your Honor, I think you would go to the North Carolina General Assembly and ask for them to make an appropriation to refund the monies. Because I think the nature of the relationship is statutory. The General Assembly has charged the board or directed the board. There are shall words in that statute. And so I think that's where you go. You don't find any statutes talking about when a refund is due. And I think that's where, I don't know if there's some kind of claim. I am confident under North Carolina law, it is not a contract claim, at least not if the things that you purport to have created the contract are websites and marketing materials and handbooks and bulletins. I think you go to the General Assembly. Your Honor, I was talking about Montessori and what this court decided there. And there the court decided that exactly these kinds of things that are alleged to have formed the contract, these online statements by the university like, make Boone your home away from home, are the basis for a contract. And if you go to page 28 through 33 of our brief, you'll see collected there a number of cases which are the jumping off point for Montessori. Cases both in this court and in the federal courts where the courts have said, no, those kinds of online statements and bulletins and handbooks are not the basis for a contract unless those statements are then imported by reference or otherwise into an express contract between the parties. Your Honor, sovereign immunity. Sovereign immunity also bars plaintiffs' claims here because of the same reason. They rely on things that do not form the kind of contract required to waive sovereign immunity. North Carolina law requires that a contract to waive sovereign immunity be express and valid. And the requirement of an express contract is found in Chief Justice Mitchell's opinion in Whitfield, where he emphasizes with italics, express and valid. An implied in fact contract is not an express contract. And the whole reason for an express contract is so that the parties know what the terms are. When you go on a website and you pick and choose, and think about this, at the universities, every department has their own webpage. Each school has its own webpage. The School of Public Health, the law school, the School of Arts and Sciences. If you are going to hold the university as contractually bound by everything that is said on those websites, if you will let a plaintiff go in and pick and choose and say, well, they said make Boone my home away from home. Do we have to build them a house? It's just silly to think that that is the basis for an express contract. And that's why they fail here, because there is a heightened pleading standard. And if you look at the case law, particularly, I think it's Wood v. NC State, this court has said that in assessing a statute that purports to waive sovereign immunity, the legislative intent must be clear, that any such waiver must be by, and I quote, plain, unmistakable mandate of the lawmaking body. And finally, the court says that that law is going to be strictly construed. That's why it has to be an express contract. That same philosophical underpinning. If you're going to bind the state, it has to know when it enters into the contract what it's bound to and to do.
Okay, and you're at your time, so you can just sum up briefly.
Am I past my time?
Well, you're past, yeah. So just,
I'm sorry.
that's okay.
So in any event, Your Honor, we believe that there are multiple reasons to affirm the trial court's decision: the immunity statute, sovereign immunity, the fact that under North Carolina law, there's just not a contract here. We ask you to do that. Thank you.
Thank you. All right, and I said I'll give you like 3 minutes for rebuttal.
May it please the court, just a few points here on rebuttal. I first want to address the emergency immunity statute that was put in place, and in our position in regards to how it does not apply to breach of contract claims. Appellee has taken the position that, based upon the definition of claim, it simply applies to each and every single claim possible. But it's as easy as going right to the applicability section of the statute itself. And the applicability section of the statute itself says that it relates to alleged acts or omissions, and we make no such allegation. We only make allegations of breach of contract. There are no allegations of negligent acts or omission. So based upon the applicability section of the statute alone, it simply does not apply to breach of contract cases. And there's other cases.
Don't you act when you breach a contract? Isn't that an action to actually breach a contract? Or an omission to breach a contract? No?
Respectfully, no, Your Honor. That's not an element of breach of contract. It's certainly
Well, I
an
know
element.
it's not an element of breach of contract, but don't you actually have to do something in order to breach the contract? You breach it.
I suppose you would have to stop performing at some point in time, but I think that given the strict reading of the statute itself, acts or omissions should be construed as an element of a cause of action, and that would sound in tort. And so basically, just based upon the applicability section of the statute itself, it cannot apply to breach of contract claims. And there's actually other courts that have held the same and similar statute. I would ask that your honors refer to the Colorado cases, Alderman versus Colorado State, Levin versus the University of Colorado, and Kishabitsky versus, if I'm pronouncing that correctly, Denver Metropolitan, interpreting a similar statute. And to my next point, I respectfully disagree with Appellee's interpretation of the Blizzard case and what that means to the relationship contractually between students and schools. In that case, there was a tuition agreement statement that was actually read, entered into, and signed by the parents of the individual that they enrolled at the school. It was an elementary school. And basically what this agreement said was, in exchange for us to enroll your student at our school for the duration of the year, you are agreeing to pay for tuition. And that's the exchange for a contract. Basically what the court said is, we have a contract, and we don't need to go outside the four corners of that contract. We have a written contract that's fully integrated. So they just disregarded other areas in which provisions of a contract could come into. And I think this actually goes away from the Ryan case versus the North Carolina State University or in hospitals, where they basically said, and this was a first impression case, they basically said, we've never really had a situation like this. We need to figure out whether or not a student can sue an institution for breach of contract, and if they can, what for? And so in that case, Ryan looked to basically the seminal case, which was the Ross v. Creighton University. And in that case, it makes it very, very clear that the relationship between universities and students is contractual in nature, and the terms of those contracts can come from sources such as...
So you're at a minute.
Excuse me?
You're at a minute.
Sorry.
You've got a minute, so I'll let you.
Oh, no. I just want to say that I think that respectfully that's not the whole picture of contract interpretation, and I think that we lay that out in our papers. And for the foregoing reasons, we respectfully request that this court reverse the lower court's dismissal of the complaint in this matter. Thank you.
Thank you very much. Thank you so much for your arguments.